wants. Oh. Yes, I'm a member for St. James North.
Thank you, Mr. Speaker. We are here today debating on the amendment to Magistrate's Court Act of Barbados. In a lot of cases, you know, politicians generally are of the view in a lot of cases that the administration of justice is not as sexy an area as others. It doesn't bring votes like provision of housing or jobs or provision of lights, street lights and roads, but it is a major aspect of our society and of the proper functioning of any independent country, and it is an important area of law. The Honourable Member for St. Joseph, in his lead speech on behalf of the opposition, spoke towards the opposition supporting this bill and disclosed, in fact, that this bill would have originated, you know, while the Barbados Labour Party was last in office. It is an attempt, of course, to try and, in some way at Magistrates Court level, deal with the fundamental inefficiencies of the system. I remember when I used to practice criminal law, 25 years ago and more, in the late 1980s, early 1990s, an attempt was made to improve the system by way of preliminary inquiries in criminal matters, whereby written statements would have been given at Magistrates Court level for indictable offences, offences that came then before the High Court of Barbados. This system clearly didn't work as well as those who established it had hoped it would work. This is now a system, as I understand it, these amendments, an attempt to have more written statements at committal proceedings in the hope that it would speed up the process. The reality of the situation, Mr. Speaker, as all the practicing attorneys at law in this House know and or ought to be aware, is that the administration of justice in this country is at a very low ebb. It is no different in that respect, sir, than many aspects of the functioning of this society. The teaching profession, the area of education, complete disarray almost. Issue of provision of housing, public sector housing in Barbados, almost none being provided at all since the Honourable Member for St. Lucie took over the ministry 3.5 years ago. I don't believe that 25 houses have been built in this country. The roads in this country in a terrible state of disarray, even though this Parliament has voted millions of dollars for the repair of roads in this country. The Honourable Minister of Transport seems incapable of getting any road repairs on the way. The issue of the health sector in this country as well, continuing to decline. Millions of dollars owed to health service providers by the Queen Elizabeth Hospital, and yet we still hear on the last session of Parliament about a pre-feasibility study being done for an airport which will never come into existence, just to try to please the Honourable Member for St. Lucie. Many aspects of Barbados are breaking down, if they have not yet broken down completely, Mr. Speaker, and the administration of justice is just another area that we go through. It is a situation where many people in this country, especially poor people, feel that there's no ready access to justice. And that is a very sad situation, that it takes too long to get their cases heard. When their cases are heard, it takes too long for decisions to be made. There's the feeling by many persons in this country that being poor is a disadvantage in terms of access to justice and administration of justice in this country, where young fellas are jailed for a couple sniffs of marijuana or for stealing a tin of corned beef worth $4 from a supermarket, but yet an individual or individuals can unfortunately deprive 30,000 people at a major insurance company in this country and not be brought before the courts. And yet the public hear that, you know, the individual who is head of the insurance company is a pal of the Prime Minister, and that the Prime Minister has more faith in his integrity than in that of the leader of the opposition. I mean, these things go down and send a message to the people of this country who do not have the money or the influence, or who cannot drink champagne with the Minister of Finance, as this individual does at Gold Cup. You know, these are the alimonies and the injustices of this country that the people who in Western or in Sion Hill or in Ashton Hall speak about. I don't know if they speak in the constituency of St. James South, with the honourable member here trying his best to intervene when he will have an opportunity if he wishes to speak after me, rather than breaching the rules of the House and not allowing me to speak in silence. These are the kind of issues that certainly I am concerned about, and which I would have thought that the Attorney General would have used the opportunity today to discuss. We have a situation where for 7 months there has been no Chief Magistrate in this country. We are bringing an amendment to the Magistrates Court Act here today, in a situation where there has been no chief of those courts since the last judge was appointed after she was promoted from her position as Chief Magistrate 7 months ago. No, that can't be happening, Mr. Speaker, in a country that is celebrating 50 years of political sovereignty and, independent decision-making by those elected by the population. We have a situation, Mr. Speaker, where there has been no magistrate at Oyston's Court for months. Oyston's Court, a major court. Most likely, I think most lawyers all would agree that it's probably the second most important court in Barbados after District A. In fact, a previous Chief Magistrate, the late Frank King, used to sit at Oyston's Court when people like the Right Honourable Prime Minister and myself were early in our practice of law. He used to sit there at Oyston's. There's been no magistrate and therefore no functioning of the Magistrates Court at Oyston's for months now. And the Attorney General, one would think, within the mandate of his political party, that the Democratic Labour Party is in for good governance, that is something that I would think should be of concern to him, and that he should be telling us today what systems he is putting in place to solve these issues. What are we doing as the political leaders of this country to alleviate the tremendous amount of time wasting involved in the process of court in this country, whether at magistrates court level, whether at the High Court, Supreme Court level, or whether at the Court of Appeal level. You go in court on any given day, Monday to Friday, in the High Court, dozens and dozens of people there just standing around doing nothing, waiting on a case to be heard. When, I mean, you could set down some cases for 9:30, some for 10, 11:30, whatever, and where our presiding officers should, as a matter of course, be working in the afternoons as well. I mean, some do, yes. Let us concede it is better now than it used to be. But it is certainly better now than when, in terms of judicial officers working in the afternoons, than it was, I think, about 25 years ago or more, 27 years ago, when the late Prime Minister David Thompson referred to some magistrates as foolish magistrates. It is better now, we agree with that. And at that time, in fact, if I recall, the then government amended the law to allow for matters to go to the High Court on appeal from the Magistrates Court after 3 weeks, even if the magistrate didn't give a written decision. That is what, but that kind of initiative was taken, and that is the kind of initiative that a parliament can take to solve issues using its vision and its initiative, but which you see sorely lacking from the government of today in terms of how to resolve the tremendous problem which is the administration of justice in this country at the present time. It is frustrating to people, and I mean frustrating to my constituents. I have constituents who have matters, and certainly all members of this parliament do, and it should be of concern to you all, to the members on the other side as well. The time wasting, the frustrating nature, the adjournments that take place, as of course we have to get rid of this culture of adjournments. That is the one thing in the Attorney General's speech that I agree with. And judges ought not to be given adjournments as a matter of course like that. They should be backed by penalties paid by the attorneys at law involved if the case merits itself. We have situations, yes, there was an attempt now in terms of the High Court with the civil procedure rules coming into effect 8 years ago to try to reform the system. It hasn't helped that much. Cases still taking too long to be heard, cases still taking too long to be decided. One time I recall, Mr. Speaker, a newspaper reported that a particular judge took 4.5 years to give a decision, and that judge came in the paper on the next day and said, no, it was not 4.5 years, it was in fact 3 3/4 years, like if that was acceptable. I think that the time has come, Mr. Speaker, for this Parliament, for this government, to bring before this Parliament a limitation of time period for rendering of judicial decisions act. Guyana has brought it, compelling their judges to give a decision within 6 months of the case ending. There is absolutely no reason why a judge, someone trained to be a judge, cannot give an oral decision as soon as a case is finished. In fact, that is the best time to render a decision, when all the facts are fresh in your mind, when you have seen the demeanor of the witnesses, you have seen the body language of each witness, and from that you are able to tell with your experience in life and as a lawyer and as a judge who is telling the truth and who is not telling the truth, who is sincere, etc. That is the best time to give a decision, not to put down the case and then the next year or a year and a half or 2 years attempt to give a decision when you forget everything about it and the demeanor of the witnesses. Our judges should be given a decision within 6 months. In Guyana, if 3 weeks before the 6-month time period is about to expire, a judge feels that they cannot render the decision within the 6-month time period, they have to, in fact, write before to a commission, which is overseeing the judges, and give reasons why they can't give that decision within the 6-month time period. They're given time off by the head of the judiciary to go home, 2 weeks, 3 weeks, whatever, and write that decision. In Trinidad, as a matter of course, because a lot of the judges in Trinidad are contemporaries at law school of yes, the Right Honorable Prime Minister and myself, most of the judges are our contemporaries. They tell us, certainly they tell me, that, I mean, there's no question about delaying writing decisions. That is no problem whatsoever. But we, as the political directorate, have to lead the way. And if the judges won't give their decisions, put some time limits on them by way of legislation. Rather than that, we see judges, a lot of them routinely retire with decisions outstanding and still be paid the gratuity. They should not be paid their gratuity. My submission until they write and render all outstanding decisions. This is a major problem. These are the issues that we need to address, that we ought to be addressing in here today. We have the situation, Mr. Speaker, we heard about the fact that the government plans to appoint more judges, or rather that's the Prime Minister's purview now, since the 1974 amendment to the Constitution of Barbados. That is the Prime Minister's purview. So the Attorney General might plead, that's not my fault. But last year, around this time last year, we heard about the appointment of 3 more judges. And in fact, as I understand it, those judges were to be paid out of the Canadian Justice Improvement System, of which the Attorney General spoke this morning. As I understand it, their salary was not coming from the taxpayers of Barbados or the government of Barbados. Yet up to now, well, if that is not true, it could be clarified. But I know that 3 judges were to be appointed. That was said. In fact, I know that the 3 were approached, were named, had given their consent. Those 3 judges have not been appointed up to now. And as I understand it, this same Canadian Justice Improvement System money, some money that was earmarked for Barbados, has now gone to the same Grenada that the Attorney General mentioned has gone ahead of Barbados. That's what he said this morning. In terms of the system, money that was earmarked for Barbados has gone down to Grenada because of the laziness and the ineptness of the Barbados government on the issue of administration of justice, and not putting the systems and procedures in place so that the money can be accessed. That is my understanding, and if the Right Honourable Prime Minister says no, I understand that from very good sources. If that is not so, bring me the evidence to show not. That this has not been a priority for the government of Barbados, just like how many aspects of the functioning of society has not been a priority. The fact is that the 3 judges haven't been appointed. That cannot be denied. And really and truly, Mr. Speaker, I don't even know. You could appoint probably 10 judges. I don't know how much good that will do if the basic system, the basic culture that has become ingrained in the functioning of the administration of justice in Barbados is not addressed. This is a major issue that has to be addressed. We know, Mr. Speaker, that yes, as was said earlier, the Honourable Chief Justice has issued 2 practice directions on the 15th of April this year, 3 months ago, relating to court annex mediation. One, practice direction, one dealing with the High Court, and practice direction, two, dealing with the Magistrate's Court. In fact, the direction made under practice direction 2 would be made under, I believe, regulations arising out of this Magistrate's Court Act that we are looking at today. We wish luck on that. Yes, there is the mentality of a lot of lawyers, yes, they want the matter litigated, but that is a dead end. I mean, that you file a case and 5 years from now it hasn't even reached court, and then when it does, another 2-3 years to go through the system till it heard, and then another 3-4 years in a lot of cases to get a decision. Mediation, yes, is the way to go. I know there's the feeling as well among some aspects of the bar that you need a mediation act as well to strengthen these practice directions. I believe at one time there was a draft mediation act in which the former Chief Justice, Sir David Simmons, was involved in, but certainly we haven't heard about such a mediation bill again in the last 8.5 years under this government. Maybe we could look at that, the government, in terms of buttressing these practice directions and to try to gain a culture of mediation in this country. But the issue of administration of justice, of course, is closely tied in with the issue of law and order in the country. And we have to keep a strain on it as political leaders of this country to make sure that there's no breakdown in the law and order of this country. And we have to make sure that has issues relating to the police that my colleague, the Honourable Member for St. Joseph, spoke of earlier, a situation where too many members of the police force are enacting appointments because of a rising out of a court case. I mean, the police service commission and all of that. And this ought to be dealt with in the most urgent manner. But, Speaker, the question arises as well if the present member of Cabinet, who has responsibility for the Attorney General and for justice and for law and order in this country, is really capable of moving us forward into where we should be after 50 years of independence. Where are we really getting the best that we should get as Barbadians from the present Attorney General? The Honourable Member's statement last week about bail and who should get bail and who should not get bail has been quite correctly condemned universally, both in Barbados and outside of Barbados. A highly irresponsible statement by someone who is, by his office, the principal and chief legal advisor to the government and people of Barbados. That statement alone, if nothing else, renders, in my submission, the Honourable Member for St. Philip South to be unfit to hold the office of Attorney General. He intervened in a most despicable way in an area that is not his purview. Any first-year student in law or in law and politics at the University of the West Indies, Cave Hill, understands about the separation of powers. In fact, if you don't understand it, you can't pass first year. And this clearly infringed his statement on the issue of separation of powers, where you have an executive, you have a judiciary, and you have a legislature, and the three should not infringe on the other. Of course, there's overlap between the executive and the legislature. But certainly, the judiciary you do not make that statement. Just because you are before an association, a general meeting of a police association, and they make a statement which they ought not to have made either, and you now trying to please them, you go along and make a totally irresponsible statement unbefitting of the office of Attorney General. He has been correctly sanctioned, and this Parliament ought to sanction him as well. And certainly I have done that and will do that here today. That 2 days after that, then that particular individual gets bail. He put the honourable judge in a totally uncompromising compromising position.
Honourable Member, you have 3 minutes in which to conclude.
And that shows that. But, you know, it doesn't surprise me because the present Attorney General, I mean, after all, never had any presence in terms of the bar, practicing criminal or civil law in this country or in any other country. He doesn't understand constitutional law neither as chief principal or advisor to the government, because to certify that it has not breached the Constitution to fingerprint Barbadian citizens on exit or on entry into ports, the normal ports of entry into Barbados, something in clear breach of the fundamental human rights section of the Constitution of Barbados, and to certify that there was nothing wrong constitutionally in so doing shows again that he's not fit for the post. Again, a first-year student in constitutional law at Cave Hill would know otherwise. Again, I have no confidence in this Attorney General, again on issues where he has spoken about corruption, people who speak about, you know, need for anti-corruption legislation, prevention of corruption legislation in Barbados, making silly noises, as he was reported as saying earlier this year, a few months ago, shows again he's not fit for office. I mean, you have corruption at many levels in Barbados. I mean, the Prevention of Corruption Act that passed through both houses of Parliament just before last election, and which the government steadfastly refuses to have proclaimed, speaks towards this, and it would speak towards cabinet ministers driving vehicles, top-of-the-line luxury vehicles, $400,000 given to them by contractors, major contractors in their ministry, people who are getting millions of dollars out of their ministry. And who is paying for that? Who is paying for the fact that they've been given luxury vehicles to drive by these major contractors? Who else besides the taxpayers of Barbados are paying for that? But yet the Attorney General can say that people who speak about the need for prevention of corruption legislation are making silly noises. I mean, totally irresponsible statement, sending a poor message to the people of Barbados. All of these are issues that we need to address. The same Right Honourable Member, just after the election, together with the Right Honourable Prime Minister, spoke about money passing on election day and that they would address this problem with immediacy. Not one statement from either of these two high officials since that time. Yet again, of course, the Prevention of Corruption Act speaks towards campaign financing and the need to criminalise $500,000 maximum fine, or 5 years in prison, or both, speaks towards this issue. But yet nothing being done, swept under the carpet by the Democratic Labour Party government, by the Attorney General after he himself recognised that there was concern for it. That the Democratic Labour Party government intend to commit the same acts again next election, so they therefore have no need to criminalise this kind of behaviour or to proclaim the act that they themselves passed just before the election with the view to being able to tell the people of Barbados that we passed the act. But yet it is not enforceable as law.
Please wrap up.
So these are the issues that we cannot window court and play and sweep under the table in this our 50th year of independence.
Member, thank you.
I'm obliged to you.